Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Bondi v. Vanderstok. In this case, the court considered this issue. Did the ATF exceed its statutory authority in promulgating its final rule purporting to regulate so-called ghost guns? The case was decided on March 26, 2025. The Supreme Court held that the Gun Control Act of 1968 authorizes the ATF to regulate weapon parts kits and unfinished frames or receivers that can be readily converted into functional firearms. Justice Neil Gorsuch authored the 7-2 majority opinion of the court. Weapon parts kits qualify as weapons under the statute when they contain all necessary components to build a gun and their intended function is clear. Everyday language permits describing incomplete objects by their intended use, just as a disassembled rifle remains a weapon. The statute reinforces this understanding by treating starter guns as firearms even though they require modification. A kit like Polymer 80's Buy Build Shoot, which can be assembled in about 20 minutes using common tools, meets the law's definition because it can be readily converted into a functioning firearm, just as a blocked barrel starter gun qualifies when easily modified for live fire. While not all kits may fall under this definition, the statute clearly covers at least some, making a facial challenge to the rule invalid. The definition of frame or receiver also includes partially complete versions that can be finished quickly with standard tools. Ordinary language and the statute's serialization requirements support this reading, as identification numbers are required on unfinished frames and receivers. Law enforcement has long treated such components as regulated firearms, and even the challengers conceded that some unfinished frames fall within the law's scope. While some objects may be too incomplete to qualify, the statute reaches at least those requiring only minimal work, making ATF's rule facially consistent with the law. Concerns about unintended consequences under the National Firearms Act are misplaced, as the government disavowed any authority to classify AR-15 receivers as machine guns, and the doctrines of lenity and constitutional avoidance do not apply where the statute's meaning is clear. Justices Sonia Sotomayor, Brett Kavanaugh, and Ketanji Brown Jackson each joined the majority opinion and also wrote separate concurring opinions. Justices Clarence Thomas and Samuel Alito each authored dissenting opinions. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Gorsuch delivered the opinion of the court. For decades, the Gun Control Act has regulated the sale of firearms. This case poses the question whether the Act's long-standing mandates also apply to those who make and sell a new product, weapon parts kits. Shortly after the assassinations of Senator Robert F. Kennedy and Dr. Martin Luther King Jr. stunned the nation, Congress adopted the Gun Control Act of 1968, GCA. Existing gun control measures, Congress found, allowed criminals to acquire largely untraceable guns too easily. Often, for example, criminals could evade state laws regulating in-person sales simply by purchasing guns through the mail. In response, Congress adopted a number of new mandates. As a result, many of those now engaged in importing, manufacturing, or dealing in firearms must obtain federal licenses, keep records of their sales, and conduct background checks before transferring firearms to private buyers. The Act also requires importers and manufacturers to mark their firearms with serial numbers. These mandates serve at least two ends. The background check requirement seeks to keep guns out of the hands of criminals. The licensing, record-keeping, and serialization requirements, meanwhile, aim to assist law enforcement authorities in investigating serious crimes by permitting them to determine where, by whom, or when a firearm was manufactured, and to whom it was sold or otherwise transferred. Today, thousands of law enforcement agencies nationwide depend on the Act's tracing system to link firearms involved in crimes to their owners. The GCA's mandates apply to firearms, and the law defines that key term broadly. Under Section 921A(3), a firearm includes a. any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. B. the frame or receiver of any such weapon. C. any firearm muffler or firearm silencer, or D. any destructive device. Thanks to this generous definition, the GCA has long been understood to reach everything from run-of-the-mill rifles to novelty umbrella guns. Recent years, however, have witnessed profound changes in how guns are made and sold. When Congress adopted the GCA in 1968, the milling equipment, materials needed, and designs were far too expensive for individuals to make firearms practically or reliably on their own. With the introduction of new technologies like 3D printing and reinforced polymers, that is no longer true. Today, companies are able to make and sell weapon parts kits that individuals can assemble into functional firearms in their own homes. These kits vary widely both in how complete they come and in how much work is required to finish them. At one end of the spectrum, A kit may lack essential parts and require substantial effort, specialized expertise, uncommon equipment, and a significant amount of time before anyone can fire a shot. At the other end, some kits contain all components necessary for a complete pistol and can be completed in perhaps half an hour using commonly available tools. Sales of these kits have grown exponentially. Home hobbyists enjoy assembling them, but criminals also find them attractive. That is largely due to how the kits are sold. Some manufacturers and dealers take the position that weapon parts kits do not qualify as firearms subject to the GCA. As a result, they say, they are free to sell their products without obtaining a federal license, conducting background checks, maintaining sales records, or marking components with serial numbers. The upshot? Police departments around the nation have confronted an explosion of crimes involving these ghost guns. In 2017, law enforcement agencies submitted about 1,600 ghost guns to the federal government for tracing. By 2021, that number jumped to more than 19,000. Efforts to trace the ownership of these weapons, the government represents, have proven almost entirely futile. In 2022, the Bureau of Alcohol, Tobacco, Firearms and Explosives adopted a new rule designed to combat the proliferation of ghost guns. In doing so, the agency invoked authority Congress granted it to prescribe rules and regulations as are necessary to carry out the GCA. Two provisions in the agency's new rule are of special relevance here. The first addresses weapon parts kits directly. Recall that Section 921A(3) extends the GCA's mandates to firearms, a term subsection A defines as any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. In its new rule, ATF interpreted this language to embrace weapon parts kits that are designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive. Those who make or sell kits that satisfy this test, ATF said, must comply with the GCA by securing federal licenses, conducting background checks, keeping sales records, and marking their products with serial numbers. To decide whether a kit may readily be converted into a working gun, ATF added, it will consider several factors, including the time, ease, expertise, and equipment required to complete a weapon, as well as the availability of other necessary parts. The second relevant aspect of the agency's new rule concerns a key building block of almost any firearm, its frame or receiver. Under subsection B of Section 921A(3), the frame or receiver of any such weapon covered by subsection A is itself treated as a firearm. Effectively, that means a frame or receiver is, even when sold separately, subject to the Act's requirements. Presumably, Congress singled out these components for special treatment because of the special role they play in constructing firearms. As the government put it in 1968, a frame or receiver is that part which provides housing for the hammer, bolt or breech block, and firing mechanism, and which is usually threaded at its forward portion to receive the barrel. In its 2022 rule, ATF sought to expand this definition. Now, the agency said, a frame or receiver subject to subsection B of Section 921A(3) should be understood to encompass as well a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. Still, ATF stressed, the Act and its new rule have their limits. They do not apply until an object has reached a stage of manufacture where it is clearly identifiable as an unfinished component part of a weapon. So, for example, a forging, casting, printing, extrusion, unmachined body, or similar article does not count. Before ATF's new rule took effect and ATF could begin efforts to enforce its new rule, various gun manufacturers, at-home gunsmiths, and others filed what they described as a facial challenge under the Administrative Procedure Act, APA. They argued that the GCA cannot be fairly read to reach weapon parts kits or unfinished frames or receivers. As a result, the plaintiffs contended, ATF's regulations in Section 478.11 and Section 478.12c purporting to extend the GCA's mandates to these products, could not be enforced against anyone and had to be set aside as impermissibly issued in excess of statutory authority. At summary judgment, the district court agreed with the plaintiffs and vacated the agency's new rule. On appeal, the Fifth Circuit largely affirmed. The court acknowledged that subsection A of Section 921A(3) authorizes ATF to regulate weapons that may readily be converted to expel a projectile by the action of an explosive, but, the court reasoned, that language does not reach weapon parts kits, nor does it matter how complete a kit may come or how easily it may be assembled. As a categorical matter, The court held, the Act reaches none of them. The Fifth Circuit offered a similar assessment when it came to unfinished frames and receivers. Subsection B of Section 921A(3) permits the agency to regulate the frame or receiver of any such weapon covered by subsection A. But, the court held, those terms do not speak to, and thus do not allow the agency to regulate unfinished frames and receivers, no matter how close to completion they may be. For these reasons, the Court of Appeals concluded, the provisions in ATF's new rule addressing weapon, parts, kits, Section 478.11, and unfinished frames and receivers, Section 478.12c, were facially inconsistent with GCA and thus had to be set aside consistent with the APA. The government sought review in this court. Our intervention was necessary, the government insisted, because the Court of Appeals had adopted an interpretation of the Act that would effectively nullify its central provisions and leave criminals today nearly as free to obtain untraceable firearms as they were before the Act's adoption in 1968. We agreed to hear the case. As presented to us, this case does not ask us to resolve whether ATF's new regulations in Section 478.11 and Section 478.12 may be lawfully applied to particular weapon parts, kits, or unfinished frames or receivers. Instead, the plaintiffs have pursued what the lower courts called a facial pre-enforcement challenge to the agency's authority to regulate any weapon parts, kits, or unfinished frames or receivers. In a challenge like that, the government represents, the possibility that ATF's regulation may be invalid as applied in some cases does not mean that the regulation is facially invalid. Instead, the plaintiff's burden is to show that the rule itself is inconsistent with the statute on its face. Nowhere in either of their briefs before us do the plaintiffs dispute that assessment. Accordingly, we take it as given for our purposes here. In doing so, we turn first to the question whether Section 478.11's provisions addressing weapon parts kits are inconsistent on their face with the GCA. The answer turns on subsection A of Section 921A(3). There, remember, the GCA authorizes ATF to regulate any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Inherent in this language are two requirements. First, a weapon must be present. Second, that weapon must meet one of three criteria. It must be able to expel a projectile by the action of an explosive, designed to do so, or susceptible of ready conversion to operate that way. As the Fifth Circuit saw it, Section 478.11's provisions addressing weapon parts kits are facially invalid because no weapon parts kit can ever satisfy the statute's two requirements. We disagree because, to our eyes, at least some kits will satisfy both. To appreciate why, it helps to work with an example. Take a weapon parts kit featured prominently in the record before us, Polymer 80's Buy Build Shoot Kit. It comes with all of the necessary components to build a Glock variant semi-automatic pistol, and it is so easy to assemble that, in an ATF test, an individual who had never before encountered the kit was able to produce a gun from it in 21 minutes using only common tools and instructions found in publicly available YouTube videos. The first picture below shows the kit, the second depicts the gun the kit yields. Now, assess whether the Buy Build Shoot Kit meets subsection AS2 tests, and start with the question whether Polymer 80's offering qualifies as a weapon. When Congress adopted the GCA in 1968, that term meant what it means today, an instrument of offensive or defensive combat, such as a club, sword, gun, or grenade. As a result, ATF's authority under subsection A extends only to instruments of combat, not to other things like industrial tools or toy guns that may expel a projectile by the action of an explosive. It is a feature of the statute the agency itself has long acknowledged. Plainly, the finished Buy Build Shoot Kit is an instrument of combat. No one would confuse the semi-automatic pistol pictured above with a tool or a toy. Of course, as sold, the kit requires some assembly, but a number of considerations persuade us that, even as sold, the Buy Build Shoot Kit qualifies as a weapon. Consider, first, a feature of ordinary language. The term weapon is an artifact noun, a word for a thing created by humans. Artifact nouns are typically characterized by an intended function, rather than by some ineffable natural essence. Reflecting as much, everyday speakers sometimes use artifact nouns to refer to unfinished objects, at least when their intended function is clear. An author might invite your opinion on her latest novel, even if she sends you an unfinished manuscript. A friend might speak of the table he just bought at IKEA, even though hours of assembly remain ahead of him. In both cases, the artifact noun fits because the intended function of the unfinished object is obvious to speaker and listener alike. The term weapon can work this way too. Imagine a rifle disassembled for storage, transport, or cleaning. It may take time to render the rifle useful for combat, but its intended function is clear. And, as a matter of everyday speech, that rifle is a weapon, whether disassembled or combat ready. In the same way and for the same reason, an ordinary speaker might well describe the buy build shoot kit as a weapon. Yes, perhaps a half hour of work is required before anyone can fire a shot, but even as sold, the kit comes with all necessary components, and its intended function as instrument of combat is obvious. Really, the kit's name says it all: buy build shoot. Next, consider what the statute itself has to say about the term weapon. Subsection A tells us that the term includes a starter gun. A starter gun, of course, normally fires blanks, not bullets, and is usually found at sporting events, not in combat. To be sure, a starter gun can be converted to live fire using a power tool commonly available at hardware stores. For someone with no specialized knowledge, the process can take less than an hour. But, notably, the statute teaches that a starter gun is a weapon before anyone invests that work. All of which indicates that Congress used that term, as an ordinary speaker might, to embrace some unfinished instruments of combat like polymer 80s product. Finally, notice another feature of the statute. If Congress had wanted to regulate only operable firearms, it could have simply addressed weapons that can expel a projectile by the action of an explosive. But Congress didn't stop there. Instead, Congress explained that a weapon also qualifies for regulation if it is either designed to accomplish that function or capable of being readily converted to do so. Those latter provisions necessarily contemplate that some things short of fully operable firearms will qualify as weapons. And if that is true, it is difficult to see how the easy-to-assemble buy-build-shoot kit might not be among them. Of course, to implicate the act, not only must a weapon be present, that weapon must meet one of the just recounted conditions. At a minimum, that means a weapon must be capable of being readily converted to expel a projectile by the action of an explosive. As we see it, the buy-build-shoot kit satisfies that test too. Begin with what we can glean about the ready conversion standard from the statute. We know that Congress's direction that a starter gun is a weapon would be pointless unless a starter gun satisfies all subsection A.S. terms. For the statute to make sense, then, a starter gun must be able to fire bullets, designed to do so, or capable of ready conversion to operate that way. Generally, however, a starter gun meets neither of the first two conditions, for its barrel is deliberately blocked. That leaves only one serious possibility. It must be that a starter gun can readily be converted to expel projectiles by the action of an explosive. That turns out to tell us all we need to know about the statute's ready conversion test. As we have seen, a person without any specialized knowledge can convert a starter gun into a working firearm using everyday tools in less than an hour. And measured against that yardstick, the buy-build-shoot kit can be readily converted into a firearm too, for it requires no more time, effort, expertise, or specialized tools to complete. If the one meets the statutory test, so must the other. Admittedly, our reasoning here has its limits. Just because some kits, like polymer 80s, qualify as weapons that can readily be converted into working firearms does not mean all do. Think of the problem of the heap. Start with a heap of sand and begin removing grains. At some point, a heap no longer exists. That problem attends many artifact nouns. Even when used to capture unfinished products, artifact nouns generally reach only so far. It would be extravagant to speak of a novel when the author has dashed off only a few lines. Few would call a pile of unfinished logs a table. Subsection A may present a similar problem. Weapon parts kits vary widely. Not all come as complete as the buy-build-shoot kit. Some, too, may require more time, expertise, or specialized tools to finish. And at some point a kit may be so incomplete or cumbersome to assemble that it can no longer fairly be described as a weapon capable of ready conversion into a working firearm. While we recognize the problem, this case does not require us to untangle exactly how far subsection A reaches. The plaintiffs argue only that Section 478.11's provision addressing weapon parts kits is facially inconsistent with the statute. The Fifth Circuit adopted the same view after coming to the unqualified conclusion that weapon parts kits can never satisfy the statute's two tests. To resolve this case, it is enough to say those assessments are mistaken, because at least some weapon parts kits satisfy both of subsection A's tests. Section 478.11 is not facially invalid. Future cases may present other and more difficult questions about ATF's regulations, but we take cases as they come and today resolve only the question posed to us. B. The plaintiffs dispute little of what we have said. They admit that artifact nouns sometimes capture unfinished articles. They recognize that starter guns qualify as weapons even though they require work before they operate as functional firearms. The plaintiffs concede, too, that disassembled rifles and guns are weapons that can be readily converted to live fire because they have all the parts necessary for an ordinary person to put together a functioning firearm in short order. Really, the plaintiffs fail only to take the next step and acknowledge that the same might be said of some weapon parts kits. Given all that, what do the plaintiffs have to say in support of the Fifth Circuit's conclusion that subsection A reaches no weapon parts kits? Perhaps their best argument centers on the fact that other statutes address collections of parts while this one does not. As the plaintiffs observe, Congress has elsewhere defined a destructive device to embrace any combination of parts, from which a destructive device may be readily assembled. Similarly, Congress has specified that the terms firearm silencer and firearm muffler encompass any part or combination of parts used to assemble or fabricate those items. Subsection A, meanwhile, employs none of those terms. And because Congress has spoken elsewhere to collections of firearm parts, the plaintiffs insist, we should infer this statute does not address parts or kits containing any combinations of them. The plaintiffs' conclusion, however, does not follow from their premise. We do not doubt that subsection A sweeps more narrowly than some other statutes. No one thinks it reaches every piece or part that can be used to produce a firearm. Recognizing as much, ATF itself acknowledges that subsection A does not allow it to regulate standalone triggers, barrels, stocks, or magazines. Nor, the agency admits, does the statute authorize it to regulate weapon parts kits writ large, without regard to how complete they come or how difficult they are to assemble. But the fact that subsection A doesn't go as far as some other statutes does not tell us how far it does go, let alone prove that subsection A fails, as a categorical matter, to reach any weapon parts kits. Faced with that problem, the plaintiffs, joined now by the dissent, try another tack. They object that weapon parts kits cannot be weapons under subsection A, because they lack functional frames or receivers. That conclusion rests on two premises. 1. That a weapon must have a fully functional frame or receiver, and 2. That no weapon parts kit includes such a part. But neither premise is sound. For one, the statute nowhere says that a weapon must have a fully functional frame or receiver, nor is it obvious how we might derive such a rule from its terms. In fact, as we have seen, subsection A reaches any weapon that may readily be converted to live fire, and a gun that is fully operable, save for a frame missing a single and easily added screw, would surely fit that description. For another, even if the statute did require a weapon to have a fully functional frame or receiver, some weapon parts kits may fit that description. Imagine a kit identical to Polymer 80s in all respects, except that it has a complete frame. Even the plaintiffs would have to admit that such a kit would count as a weapon under subsection A. Failing all else, the dissent suggests that other criminal statutes addressing firearms prove that weapon parts kits cannot fall within the statutory definition of that term. So, for example, the dissent observes that Congress has penalized the use of firearms during and in relation to a crime of violence, required firearms to be unloaded during transportation, and permitted law enforcement officers to carry concealed firearms. And, the dissent continues, it is hard to imagine how any of those provisions might apply to weapon parts kits. As a result, the dissent insists, we should prefer a reading that limits the term firearm to completely operable guns. This argument suffers at least two problems as well. First, what the dissent finds hard to imagine turns out to be anything but, for various criminal laws addressing firearms can apply to weapon parts kits. Just consider some of the laws we have already encountered that require those who import, manufacture, or deal in firearms to obtain federal licenses, keep records of their sales, and conduct background checks. Plainly, those criminal laws can be applied sensibly to weapon parts kits. Or, to take one of the dissent's own examples, a weapon parts kit might be possessed in furtherance of a crime of violence in violation of Section 924C, 1, when an individual accused of attempted robbery purchases the kit for assembly and use in an upcoming heist. Second, the dissent's complaint is hardly resolved by adopting its view of the statute. The dissent must acknowledge, for example, that standalone frames or receivers and silencers qualify as firearms, for the statute tells us so expressly. Yet, only rarely would someone use a standalone frame or receiver during a crime of violence, and it may be impossible to unload a silencer during transportation. So whether one adopts our interpretation or the dissent's, not every firearm will be capable of implicating every criminal law discussing firearms. It's a fact that, if it proves anything, proves only that Congress's definition of firearm is a capacious one indeed. That leaves the question whether ATF's new regulation addressing unfinished frames and receivers, Section 478.12c, is facially inconsistent with the GCA. The answer here turns on subsection D of Section 921A, 3. That provision of the statute permits the agency to regulate the frame or receiver of any such weapon. As the Fifth Circuit saw it, this language reaches only finished frames or receivers. So those who make, import, or sell partially complete frames or receivers may do so free from the GCA's mandates, no matter how quickly and easily their products can be finished, and ATF is powerless to hold otherwise. Once again, the plaintiffs ask us to endorse that categorical conclusion. And, once again, we find we cannot. The GCA reaches, and permits ATF to regulate, at least some partially complete frames or receivers. Working with another example drawn from the record helps illustrate why this is so. The first photograph below depicts the complete frame of a Glock variant firearm, the second a partially complete frame that Polymer 80 sells. The main differences between the completed frame and Polymer 80's product are the plastic tabs circled in red. The record suggests that those tabs are easily removable by a person with novice skill, using common tools, within minutes. Once the tabs are gone and a few holes are drilled for the pins that hold other parts in place, again, a task that anyone can complete in minutes, the Polymer 80 product is a fully functional frame. A number of reasons persuade us that this qualifies as a frame for purposes of subsection B. First, like the word weapon in subsection A, the terms frame and receiver in subsection B are artifact nouns. And, as artifact nouns, they may sometimes describe not yet complete objects. Recall the author who refers to her manuscript as a novel, or your friend who calls his IKEA kit a table. In much the same way, an ordinary speaker might well call Polymer 80's product a firearm frame, even though a little work is required to complete it. Just look again at the second photo. What else would you call it? Next, consider how the GCA uses the words frame and receiver elsewhere. Section 923I spells out the Act's serialization mandate. It requires those who make or sell firearms to identify their products by means of a serial number engraved or cast on the receiver or frame. Though this directive may seem simple enough, it is complicated by the fact that the statutory definition of firearm includes some incomplete weapons, mufflers, silencers, and destructive devices. Sometimes, those items lack a finished or prototypical firearm frame or receiver. Yet, all the same, Section 923I treats them as firearms that must have a serial number engraved or cast on their frames or receivers. And if the words frame and receiver encompass some unfinished and unconventional frames or receivers in Section 923I, it is hard to see how those same words might bear a more restrictive meaning when they appear just a few sections away in Section 921A, 3b. Here too, examples help. Imagine a handgun that is otherwise ready to shoot, but contains Polymer 80's incomplete frame. An ordinary person, using ordinary tools, can finish the frame in minutes. For reasons explored in Part 2, supra, that gun is a weapon capable of ready conversion into a working firearm under subsection A. So Section 923I requires the gun's frame, the very item that isn't fully finished, to bear a serial number. Along similar lines, consider silencers. They lack traditional frames, but Section 923I requires manufacturers and importers to serialize them. To accommodate that instruction, ATF has long deemed the outer tube, that provides housing or a structure for the primary internal component, to be a silencer's frame or receiver. In all these ways and more, Section 923I uses the phrase frame or receiver to reach some unfinished and unconventional frames and receivers, making it only sensible to think the same phrase does the same work a few doors away in Section 921A, 3b. The novelty of the plaintiff's complete items only reading of subsection B supplies another strike against it. Without question, ATF's new rule seeks to regulate a greater variety of unfinished frames and receivers than the agency has in the past. But it is equally true that, for decades, the agency has consistently interpreted subsection B to reach some unfinished frames and receivers, including ones no more finished than Polymer 80's product. And while courts must exercise independent judgment in determining the meaning of statutory provisions, the contemporary and consistent views of a coordinate branch of government can provide evidence of the law's meaning. Last but not least, the plaintiffs represent that they have no quarrel with ATF's prior practice. It is a concession that all but gives the game away. Of course, the plaintiffs think the agency's new rule reaches further than the statute can bear by seeking to regulate some products too far removed from finished frames or receivers. But for our purposes, what matters is that even the plaintiffs do not really insist that subsection B reaches only finished frames and receivers. Here, again, our reasoning has its limits. In saying that a product like Polymer 80's qualifies as a frame, we do not suggest that the GCA reaches, and ATF may regulate, any combination of parts susceptible of conversion into a frame or receiver with sufficient time, tools, and expertise. Like the term weapon, the artifact nouns frame and receiver have their bounds. Some products may be so far from a finished frame or receiver that they cannot fairly be described using those terms. But this case requires us to explore none of that. The plaintiffs do not challenge ATF's new rule as applied to particular products. They argue only that Section 478.12 is facially inconsistent with the GCA. And, here again, we have no trouble rejecting that unqualified view. Resisting our conclusion on this score, the plaintiffs and dissent press three main replies. First, they point to a linguistic difference between subsections A and B. In subsection A, Congress chose to regulate weapons that can readily be converted into operating firearms. Meanwhile, in subsection B, Congress spoke only of frames or receivers, not parts that can readily be converted into those things. And, as the plaintiffs see it, that omission counsels against reading subsection B to reach any unfinished frames or receivers. This argument fails to persuade us for a number of familiar reasons. For one, it does not account for the fact that ordinary speakers sometimes use unadorned artifact nouns like weapon, frame, or receiver to reach unfinished articles. Adopting the plaintiff's argument would also require us to read the phrase frame or receiver in Section 921A, 3b, to embrace only finished products, even though Section 923I's use of the same phrase sweeps more broadly. To accept this argument, we would have to disregard as well the plaintiff's concession that the terms frame and receiver in subsection B are properly understood, as they have been long understood, to reach some unfinished frames or receivers. Even beyond all that, reading subsection B, in light of subsection A, does more to undermine than to advance the plaintiff's cause. Subsection B speaks of the frame or receiver of any such weapon. That italicized phrase refers us back to weapons encompassed by subsection A, and, as we have seen, the term weapon in subsection A encompasses some things that are not yet fit for effective use in combat, including starter guns and disassembled rifles, as well as certain weapon parts kits. Subsection B expressly incorporates that definition of weapon. And, if anything, the fact that Congress used one artifact noun, weapon, in subsection B to reach some unfinished articles suggests it used two other artifact nouns, frame and receiver, in the same way in the same provision. Second, the plaintiffs and the dissent contend our interpretation of subsection B could invite a serious unintended consequence under a separate statute, the National Firearms Act, NFA. That law bans the possession of machine guns, a term Congress has defined to include the frame or receiver of any such weapon. Interpreting the GCA to reach some unfinished frames or receivers, the plaintiffs reason, might lead the government to attempt a similar reading of the NFA. And if the government takes that step, the plaintiffs suggest, it might next attempt to classify the receiver of an AR-15 rifle as a machine gun because it is possible to convert those receivers to function as machine gun receivers. That result, the plaintiffs warn, could leave many Americans facing new and unforeseen criminal liability for possession of a machine gun simply because they own a popular and commonly available rifle. The plaintiffs' fears are misplaced. The government represents that AR-15 receivers do not qualify as the receiver of a machine gun. Nor, the government emphasizes, has ATF ever suggested otherwise. Much the same can be said of our reasoning today. As we have stressed, a statute's text and context are critical to determining whether, and to what extent, Congress used an artifact noun to reach unfinished objects. And, without doubt, the NFA and the GCA are different statutes passed at different times to address different problems using different language. Our analysis of the GCA thus does not begin to suggest that ATF possesses authority to regulate AR-15 receivers as machine guns under the NFA. Third, the plaintiffs criticize ATF's rule for permitting the agency to consider jigs, tools, and instructions when deciding whether an incomplete frame or receiver is close enough to the finished product to fall under subsection B. The dissent echoes the complaint, offering a photo from the record depicting various tools and jigs. But if this is a problem at all, it is one for another day. As litigated, this case does not call on us to address what weight, if any, ATF may lawfully give jigs, tools, and instructions when deciding whether a frame or receiver is present. This case requires us to answer only whether subsection B reaches some incomplete frames or receivers. Saying that it does is enough to resolve the dispute before us. The plaintiffs close by asking us to invoke the rule of lenity or the doctrine of constitutional avoidance to resolve in their favor any ambiguities about Section 921A, 3. But neither lenity nor avoidance has any role to play where text, context, and structure decide the case. And even if ambiguities at the outer boundaries of subsections A and B emerge in future disputes involving the application of those provisions to particular products, no room for doubt exists about the answer to the question the parties have posed to us. The GCA embraces, and thus permits ATF to regulate some weapon parts kits and unfinished frames or receivers, including those we have discussed. Because the Court of Appeals held otherwise, its judgment is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Sotomayor, concurring. I join the court's opinion in full. I write separately to address 2 points raised in the writings that follow. The first is a concern that ATF's rule might leave regulated entities in doubt about when and how to comply with the Gun Control Act. That worry is unfounded. For more than half a century, firearms dealers, manufacturers, and importers have complied with the Gun Control Act's requirements. They have marked their products with serial numbers, kept records of firearm sales, and conducted background checks for prospective buyers. These requirements are not new to the industry, and covered entities know they must maintain familiarity with the statute and accompanying regulations to run their businesses. In fact, the Act requires such entities to obtain federal licenses before selling, manufacturing, or importing any firearms in the first place. What is new is that some manufacturers have sought to circumvent the Act's requirements by selling easy-to-assemble firearm kits and frames, which they claim fall outside the statute's scope. ATF's rule simply confirms what was already clear. The Gun Control Act does not tolerate such evasion. Its plain text covers firearm kits and unfinished frames or receivers designed for ready conversion, as the court explains. So, for entities who seek to comply with the Act in good faith, ATF's rule should come as no surprise. Nor should it create any difficulty discerning how to abide by the law. To the extent any manufacturer has doubts about whether a particular product qualifies as a covered firearm. Moreover, it can eliminate uncertainty by seeking clarification from the agency. ATF encourages manufacturers to submit potentially covered products to the agency for classification decisions. Manufacturers have long taken advantage of that process, and a failure to do so might suggest willfulness on their part. The second point I address is the suggestion that the Act permits ATF to regulate only all but assembled weapon, parts, kits, and frames as close to completion as possible. The court's opinion speaks for itself on that point and others. I encourage readers to go to the source, rather than rely on dissents, to understand what the court holds. It is the court's ruling, not the one set forth by the dissents, that binds the lower courts. Justice Kavanaugh, concurring. I join the court's opinion in full. I add this concurrence to briefly address mens rea issues with respect to ATF's 2022 rule. Under ATF's rule, an individual or business acting in good faith might nonetheless have substantial difficulty determining when weapon parts, kits, or unfinished frames or receivers qualify as firearms, and thereby become subject to the Gun Control Act's licensing, record-keeping, serialization, and background check requirements. Some weapon parts, kits, and unfinished frames or receivers may qualify as firearms, and others may not. The line is not entirely clear. Despite the vagueness of the line, the penalties for violations are significant and can include fines and imprisonment. But importantly, under the Gun Control Act, someone can be penalized for violating the licensing, record-keeping, or serialization requirements only if he does so willfully. To prove willfulness, the government must demonstrate that an individual knew that his conduct was unlawful, not merely that he knew the facts that made his conduct unlawful. Therefore, with respect to ATF's rule, the willfulness requirement should help prevent the government from unfairly penalizing an individual who is not aware that his conduct violates the law. As to background check violations, by contrast, the statute penalizes violations committed knowingly. The knowingly mens rea requires proof of knowledge of the facts that constitute the offense. Unlike the willfully mens rea, it generally does not require knowledge that the conduct was unlawful. That lesser knowingly mens rea requirement could therefore create concerns about fair notice, at least in certain cases. That said, at oral argument, the government represented that it would likely decline to charge someone for a background check violation in the kind of situation where the individual was not aware that he was violating the law. As the government seemed to recognize, if the government were to charge a background check violation against an individual who was unaware that he was violating the law, that defendant might have a due process argument based on lack of fair notice. I expect that the government will seek to avoid that potential fair notice problem by adhering to its oral argument representation that it would likely decline to bring charges in those circumstances. Justice Jackson, concurring. To me, the nature of the claim at issue in this case makes its resolution quite straightforward. No one disputes that Congress delegated rulemaking authority to the executive branch through the Gun Control Act of 1968, as amended, nor is it contested that the Bureau of Alcohol, Tobacco, Firearms, and Explosives, an executive branch agency, relied on that delegated authority to promulgate the challenged rule. Before us, respondents claim only that portions of the resulting rule exceed the agency's statutory authority. Our judicial charge, then, is to evaluate the scope of the Gun Control Act's delegation of authority to the agency, and to determine whether the agency's actions transgress those bounds. That limited exercise should be dispositive. Proper excess of authority review must focus on actual statutory boundaries, not on whether the agency's discretionary choices overlap precisely with what we, as unelected judges, would have done if we were standing in the agency's shoes. And where, as here, the statute's boundaries do not foreclose the agency's action, the excess of authority claim should meet its end. I concur because I read the court's opinion to be consistent with this view. Justice Thomas, dissenting. The government asked this court just last term to rewrite statutory text so that it could regulate semi-automatic weapons as machine guns. We declined to do so. The government now asks us to rewrite statutory text so that it can regulate weapon parts kits. This time, the court obliges. I would not. The statutory terms frame and receiver do not cover the unfinished frames and receivers contained in weapon parts kits, and weapon parts kits themselves do not meet the statutory definition of firearm. That should end the case. The majority instead blesses the government's overreach based on a series of errors regarding both the standard of review and the interpretation of the statute. I respectfully dissent. In 1934, Congress enacted the National Firearms Act, NFA, the first federal statute to regulate the firearms industry. Congress enacted this statute to provide for the taxation of manufacturers, importers, and dealers in certain firearms and machine guns, to tax the sale or other disposal of such weapons, and to restrict importation and regulate interstate transportation thereof. The NFA defined firearm narrowly. The term covered only certain short-barreled shotguns or rifles, machine guns, and silencers or mufflers. Congress broadened that definition 4 years later through the Federal Firearms Act of 1938, FFA, defining firearm to include any weapon designed to expel a projectile or projectiles by the action of an explosive, or any part or parts of such weapon. With minor amendments not relevant here, that definition endured for about 30 years. In 1968, Congress replaced the FFA with the Gun Control Act, GCA. The GCA, which remains in effect today, is the principal federal law regulating the commercial firearm market. It requires manufacturers and dealers of firearms to have a federal license, and, in most cases, to conduct background checks, maintain records, and apply serial numbers to their firearms. The GCA also imposes criminal sanctions for a variety of well-known firearms offenses. The GCA sets forth a narrower definition of firearm than the FFA did. Its definition, which governs all of Chapter 44, Firearms, Sections 921 to 934, states that a firearm is a. Any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. b. The frame or receiver of any such weapon. c. Any firearm muffler or firearm silencer, or d. Any destructive device. Such term does not include an antique firearm. Whereas the FFA had treated any part or parts of a firearm as a regulable firearm, the GCA deems only a firearm's frame or receiver to be firearm parts that qualify as a firearm in their own right. Congress left the terms frame and receiver undefined. Shortly after the GCA's enactment, the Bureau of Alcohol and Tobacco Tax Division 1 promulgated a regulation defining frame or receiver as that part of a firearm which provides housing for the hammer, bolt or breech block, and firing mechanism, and which is usually threaded at its forward portion to receive the barrel. That regulatory definition made sense. At the time of the GCA's enactment, the term frame was generally understood to mean the basic structure and principal component of a firearm. And the term receiver was generally understood to mean the part of a gun that houses the breech action and firing mechanism. Thus, ATF's initial definition of frame or receiver accorded with the term's ordinary meanings. ATF's definition also aligned with the GCA, because for any weapon to expel a projectile by the action of an explosive, the weapon must have both a mechanism that will initiate that explosion and a way to seal the firing chamber. In other words, the weapon must have a frame or receiver. Thus, by defining frame or receiver as the parts of a gun that provide housing for the hammer, bolt or breech block, and firing mechanism, ATF's initial definition fit neatly into the statutory scheme. This understanding of frame and receiver governed for over 50 years. But, ATF recently changed course, in an effort to regulate so-called ghost guns, i.e., privately made firearms built from kits or collections of unfinished parts. To tackle what it perceived to be the homeland security threat posed by the wide availability of ghost guns, the agency promulgated a rule redefining firearm, frame, and receiver. Without any change to the statute, this rule expanded the regulatory definition of firearm to include a weapon parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive. It also broadened the definition of frame or receiver to include a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. One of the rule's critical innovations is the manner in which it allows ATF to determine whether an object is clearly identifiable and thus regulable as an unfinished frame or receiver. When issuing a classification, the director may consider any associated templates, jigs, molds, equipment, tools, instructions, guides, or marketing materials that are sold, distributed, or possessed with the item or kit, or otherwise made available by the seller or distributor of the item or kit to the purchaser or recipient of the item or kit. Prior to this rule, ATF did not examine templates, jigs, or other items and materials in determining whether partially complete frames or receivers were firearms under the GCA. Instead, ATF looked to the object itself to determine whether it was sufficiently complete to constitute a regulable frame or receiver. The new definition, however, expanded the meaning of frame and receiver to incorporate items entirely separate from the object itself. According to ATF, whether an unusable, unfinished piece of metal constitutes a regulable frame or receiver can turn on a manufacturer's marketing materials. ATF offered one meager limit on its broad new definitions. Under the rule, raw material, such as an unformed block of metal or liquid polymer, will not constitute a regulable frame or receiver. Before the rule took effect, a group of individuals and manufacturers of weapon parts kits filed a petition for review challenging the rule's new definitions of frame or receiver and firearm. As relevant here, the plaintiffs alleged that the rule exceeded ATF's statutory jurisdiction, authority, or limitations under the Administrative Procedure Act, APA. The district court granted summary judgment to the plaintiffs and vacated the rule. The Fifth Circuit affirmed in relevant part. It held that ATF's redefinition of frame or receiver was an impermissible extension of the statutory text, and that the agency's attempt to redefine firearm to include a weapon parts kit stretched the statute's words too far. The government's effort to justify its unprecedented expansion of the GCA, the court explained, collapses upon a cursory reading of the text. Judge Oldham wrote separately to highlight the staggering implications of ATF's new position, particularly with respect to the AR-15, the most popular rifle in America. Observing that the rule regulates frames and receivers according to what they might become rather than what they are, and that an AR-15's semi-automatic receiver can readily be converted into a fully automatic receiver with relative ease, he concluded that, on ATF's logic, the government may regulate AR-15s as machine guns. If ATF were correct, Judge Oldham cautioned, then millions and millions of Americans would be felons in waiting. This court granted certiorari to decide two questions: whether the rule's new definition for frames and receivers fits within the statutory definition of frame or receiver under the GCA, and whether the statutory term firearm can cover weapon parts kits. Before turning to the questions presented, a threshold issue is the applicable legal standard for analyzing the plaintiff's APA challenge. Applying traditional principles of statutory interpretation, the Fifth Circuit asked whether the rule conflicts with the plain language of the GCA or casts a wider net than Congress intended. We took this case to determine whether the Fifth Circuit was correct to answer yes. I would undertake the same inquiry as the Fifth Circuit and ask only whether the rule contravenes clear statutory text or otherwise exceeds the GCA's legislatively imposed limits on agency authority. The majority takes a different approach. Asserting that the plaintiffs conceded to having brought a facial challenge, the court takes this characterization as given, and analyzes the challenge as a facial attack. In particular, the court assumes, arguendo, that the regulatory definitions are valid so long as they cover at least some weapon parts kits. This approach superficially appears to apply a framework similar to that of United States v. Salerno. There, the court explained that, to prevail in a facial challenge to a statute, the challenger must establish that no set of circumstances exists under which the act would be valid. This approach seems plainly inapt in a challenge to a regulatory definition. To define is, to settle or to establish or prescribe authoritatively. The point of defining a term in a regulation is therefore to show what the law permits and what it prohibits. But a regulatory definition that is accurate in only a single valid application cannot possibly explain explicitly, fix or establish, or set forth the meaning of a statutory term. Consider a hypothetical statute that defines motorcycle as a motor-powered, two-wheeled vehicle with pedals. If a regulatory definition copied the same language, and then added that the term shall include any motorized vehicle, the regulatory definition obviously would be wrong. Not every motorized vehicle is a motorcycle, and the fact that some motorized vehicles happen to be motor-powered, two-wheeled vehicles with pedals does not suggest otherwise. It is difficult to see how an overbroad regulatory definition becomes defensible simply because some set of circumstances exists in which the regulatory definition overlaps with the statutory definition. Treating challenges to regulatory definitions as facial challenges has substantial implications. If a regulatory definition survives APA challenge so long as just one item it covers also happens to be covered by the statute it purports to interpret, it is difficult to understand how an agency would ever promulgate an invalid definition. So long as it imports the definition Congress laid out in the statute, the agency can sweep in whatever additional conduct it wishes. No matter how far the agency expands its regulatory definition, the statutory definition inevitably will capture at least some of it. To its credit, the majority attempts to confine the effects of its approach to the facts of this case. Because the majority assumes the relevant legal standard without deciding it, it refrains from mandating this framework. Rather, it rests on its conclusion that the plaintiffs essentially conceded that the facial challenge standard applies, and it takes the application of that standard as given for this case only. So long as lower courts do not equate an APA challenge with a facial one, they are free to disregard the majority's analysis and hold that the rule exceeds ATF's statutory authority. As for the questions presented, start with the question whether the rule's new definition for frames and receivers can stand. Ordinary principles of statutory interpretation make plain that the rule sweeps too far. The terms frame and receiver in Section 921A, 3b, do not cover partially complete, disassembled, or non-functional frames or receivers. The majority reaches a different conclusion based on several interpretive errors. Most notably, the majority proceeds under the faulty premise that our standard rules of statutory interpretation do not apply to a word for a thing created by humans. In statutory interpretation disputes, a court's proper starting point lies in a careful examination of the ordinary meaning and structure of the law itself. As relevant here, Section 921A, 3, defines firearm to include a. any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, and b. the frame or receiver of any such weapon. Because the GCA defines neither frame nor receiver, we give each term its ordinary meaning. The parties agree that, in 1968, the terms frame and receiver were understood to refer to the basic structure and principal component of a firearm, and the part of a gun that houses the breech action and firing mechanism. But ATF's rule conflicts with this accepted meaning in at least two ways. First, it defines frame or receiver to include objects that are not frames or receivers, but that may be converted into them in the future. Second, it permits ATF to deem an object a frame or receiver based on marketing materials and other materials merely associated with it. The ordinary meaning of frame or receiver does not include objects that may be converted into a frame or receiver. As the government itself admits, the word convert means to change into another form, substance, state, or product, transform, transmute. If an object can become a frame or receiver only after it is changed into another form, substance, state, or product, it is difficult to understand how the object can be considered a frame or receiver even before the change occurs. As the Fifth Circuit put it, a part cannot be both not yet a receiver and a receiver at the same time. The structure of Section 921A, 3, confirms that objects that are not yet frames or receivers do not meet the statutory definition of frame or receiver. Section 921A, 3b, subsection A, of Section 921A, 3, covers weapons that are not yet functional guns but that may readily be converted into them. And the statute makes clear that subsections C, mufflers and silencers, and D, destructive devices, also cover more than finished, operable products. In contrast, subsection B covers only a weapons frame or receiver. When Congress includes particular language in one section of a statute but omits it in another section of the same act, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. This principle holds particular force here, where Congress applied broadening language to the subject matter of every subsection in Section 921A, 3, except for subsection B. Yet, in defining frame and receiver to include objects that may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver, the rule transplants the readily be converted and assembled concepts from subsections A, C, and D into subsection B, the very provision from which Congress omitted them. The straightforward reading of Section 921A, 3, is the correct one. Subsection B's omission of the readily converted and readily assembled concepts means that a frame or receiver does not include objects that are not yet frames or receivers. And, until promulgating the rule, ATF agreed with this understanding. Importantly, the designed to and readily be converted language are only present in the first clause of the statutory definition. Therefore, An unfinished frame or receiver does not meet the statutory definition of firearm simply because it is designed to or can readily be converted into a frame or receiver. Instead, a device is a firearm either 1. Because it is a frame or receiver, or 2. It is a device that is designed to or can readily be converted into a device that expels a projectile by the action of an explosive. ATF was right the first time. Tellingly, ATF's new interpretation seems to invite staggering consequences. The NFA defines machine gun as any weapon which shoots, automatically more than one shot, without manual reloading, by a single function of the trigger, and includes in that definition the frame or receiver of any such weapon. ATF has defined frame or receiver in the NFA to have the same meaning as in Section 478.12, the provision that defines those terms under the GCA. And, although an unmodified AR-15 is a semi-automatic weapon, every single AR-15 can be converted to a machine gun using cheap, flimsy pieces of metal, including coat hangers. If an object already is what it may be converted into, then semi-automatic AR-15s would seem to be partially complete, automatic machine guns. This reasoning exposes the manufacturers, sellers, and owners of AR-15s to criminal liability under the NFA. But, Congress does not hide elephants in mouse holes. An interpretive approach that would allow ATF to regulate the most popular semi-automatic rifle in America under a statute addressing automatic machine guns should give us pause. The rule's definitions of frame and receiver also contravene ordinary meaning by allowing ATF to classify objects as frames or receivers based on criteria other than the object's physical characteristics. Under the rule, any tools, instructions, guides, or marketing materials that are made available by the seller can convert an unregulated piece of metal into a regulated frame or receiver. Put another way, the mere presence of things distinct from the object at issue can somehow transform the character of the object itself. Figure 1 illustrates the rule in action. Both images in Figure 1 depict unfinished receivers. Both lack machining and indexing in the key areas. The only difference is the presence of a jig and drill bits. Yet, according to the rule, these extraneous items make an unfinished receiver a regulable firearm. The presence of items such as jigs or marketing materials that are not, and never could be, part of a frame or receiver, has no bearing on whether a piece of metal or plastic constitutes the basic structure and principal component of a firearm. Because those extrinsic items have no impact on the ordinary meanings of frame or receiver, the regulatory definition exceeds statutory text by using such items to expand the scope of those statutory terms. The majority leaves the issue of extrinsic objects for another day, deeming the issue irrelevant under its questionable facial challenge standard. The majority thus defends only the rule's coverage of items that may become frames or receivers. To do so, it substitutes novel linguistic labels for traditional statutory interpretation, mistakes outlier definitions for exemplars, and improperly imports attributes of one provision into another. The majority's statutory analysis deviates dramatically from the careful examination of the ordinary meaning and structure of the law itself that is typically at the core of this court's interpretive approach. Drawing heavily from an amicus brief and an academic paper, the majority asserts that the terms frame and receiver in subsection B are artifact nouns, that is, they are words for things created by humans. The majority argues that this type of noun is flexible enough to encompass unfinished objects. It explains that, in casual conversation, one might refer to an artifact noun such as an unfinished manuscript as a novel, or an unassembled piece of furniture from IKEA as a table. Thus, the majority argues, a frame or receiver may sometimes describe not yet complete frames or receivers. It is beside the point whether, in casual conversation, some people might use a word for a thing created by humans to discuss unfinished versions of that thing. In statutory drafting, where precision is both important and expected, the sort of colloquial usage on which the majority relies is not customary. We have expressly presumed that Congress does not draft its laws with the informality of casual conversation. Thus, we must evaluate the rule's redefinition of frame and receiver based on the GCA's entire statutory scheme, not the stereotypical conversational background on which the majority relies. That scheme, as reflected in the GCA's text, context, and structure, confirms that unfinished objects in a weapon parts kit do not meet Section 921A, 3B's terms. Dressing up colloquial usage with the artifact noun label cannot override this conclusion. The majority further argues that, because Section 923I uses the phrase frame or receiver to reach some unfinished and unconventional frames and receivers, such as the frame or receiver of a muffler or silencer, it is reasonable to interpret Section 921A, 3B, to also cover unusual frames or receivers. The majority's conclusion does not follow its premise. Section 921A, 3C, defines a firearm to include any firearm muffler or silencer. Section 923I requires licensed importers and manufacturers to place a serial number on a firearms receiver or frame. To reconcile Section 921A, 3C, with Section 923I's requirement, mufflers and silencers must have a receiver or frame even though they do not as a matter of ordinary meaning. Thus, by regulation, ATF deems a muffler's or silencer's outer tube or modular piece to be its frame or receiver. In the context of mufflers and silencers, the terms frame and receiver have context-specific meanings that cannot be generalized to other provisions in Chapter 44. As ATF explained, under the GCA, licensed manufacturers and importers must identify the frame or receiver of each firearm, including a firearm muffler or silencer, with a serial number in accordance with regulations. Calling an outer tube or modular piece of a muffler or silencer a frame or receiver thus may be justified as an attempt to square Section 923I, with Congress's decision to include mufflers and silencers within the definition of firearm under Section 921A, 3C. But the presumption of consistent usage is particularly defeasible by context, and there is no reason to think that the agency's workaround for applying Section 923I to mufflers and silencers should alter the ordinary meanings of frame and receiver in other statutory provisions that do not implicate the same problem. In this case, the statutory scheme makes clear that Section 921A, 3B's frame or receiver language does not include unfinished, inoperable objects, even if one day they may become frames or receivers. The majority further asserts that reading subsection B, in light of subsection A, actually undermines the plaintiff's position. Again, subsection A covers any weapon which may readily be converted into a functional gun. Subsection B specifies that a firearm includes the frame or receiver of any such weapon. According to the majority, that reference in subsection B implicitly incorporates subsection A's readily converted language. And, because subsection A covers starter guns and disassembled rifles that are not yet fit for effective use in combat, the majority argues that subsection B should also cover objects that are not yet usable. That conclusion does not follow. The frames and receivers referred to in subsection B are components of the weapons referred to in subsection A. While the majority is correct that subsection A's readily converted language covers weapons not yet fit for effective use in combat, there is no reason to think that the readily converted language in subsection A applies to the component parts described in subsection B, and every reason to think they do not. ATF recognized as much just a few years ago, explaining that the designed to and readily be converted language are only present in the first clause of the statutory definition. Therefore, an unfinished frame or receiver does not meet the statutory definition of firearm simply because it is designed to or can readily be converted into a frame or receiver. The majority's examples of starter guns and disassembled rifles underscore the point that an inoperable weapon does not imply an inoperable frame or receiver. While neither type of weapon is fit for effective use in combat, their frames and receivers are typically operable. We do not lightly assume that Congress has omitted from its adopted text requirements that it nonetheless intends to apply, and our reluctance is even greater when Congress has shown elsewhere in the same statute that it knows how to make such a requirement manifest. Rather than import language from one provision, subsection A, into another that conspicuously omits that language, subsection B, the Court should acknowledge that, naturally read, subsection B, is not broadened by language omitted from it but included in the more expansive text of subsection A. The Court also granted certiorari to decide whether a firearm can include a weapon parts kit. Statutory text, context, and structure confirm that this aspect of the rule also exceeds the scope of the statute. The majority's novel artifact noun methodology cannot alter this conclusion. Section 921A, 3A's definition of firearm includes any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Thus, while an object that may readily be converted into a gun qualifies as a firearm if that object is already a weapon, an object that is not already a weapon does not. The ordinary meaning of weapon does not include weapon parts kits. At the time of the GCA's enactment, the word weapon was understood to mean an instrument of offensive or defensive combat. Something to fight with, something, as a club, sword, gun, or grenade, used in destroying, defeating, or physically injuring an enemy. A weapon parts kit is not a weapon until it is converted into an operable gun. It is no more something to fight with than the sort of unformed block of metal that the rule expressly exempts from regulation. The operable gun pictured in the majority opinion is an instrument one may use in combat. The unfinished, inoperable kit pieces are not. Because these pieces do not constitute a weapon, they do not fit within subsection A's statutory definition. Statutory text and context reinforce this conclusion, as they indicate that the weapon contemplated in subsection A must have a frame or receiver precisely the parts of a weapon that weapon parts kits omit. Section 923, for example, requires manufacturers to identify their firearms by means of a serial number engraved or cast on the receiver or frame of the weapon, clearly implying that any such weapon includes a receiver or frame. Section 921 supports this reading by delimiting the definition of a firearm to any weapon convertible into a functional gun, and the frame or receiver of any such weapon. This provision again assumes that the weapon in subsection A has a frame or receiver. That starter guns and disassembled rifles are prototypical illustrations of things covered under Section 921A, 3A, that nevertheless are not yet fit for effective use in combat, underscores this conclusion. Both starter guns and disassembled rifles usually have functional frames or receivers. In contrast, the frames and receivers included in weapon parts kits are unfinished, inoperable, and so cannot constitute frames or receivers under subsection B, since any weapon must have an operable frame or receiver. Section 921A, 3B, a weapon parts kit cannot be a weapon. Accordingly, it cannot become a regulated firearm under Section 921A, 3A. Further, although the FFA previously regulated any part or parts of a gun, Congress limited the GCA's coverage to only two such parts, the frame or receiver, Section 921A, 3B. Presumably, Congress singled out these components for special treatment because of the special role they play in constructing firearms. We should presume that a legislature says in a statute what it means and means in a statute what it says there. The statute's broader context also suggests that weapon parts kits are not regulable firearms. Section 921A, 3, defines firearm for all of Chapter 44. It follows that, if Chapter 44 is to be interpreted as a symmetrical and coherent regulatory scheme, the term should to the extent possible receive a consistent meaning. While it is not difficult to envision how weapons that can be immediately assembled might be helpful during and in relation to any crime of violence under Section 924C, also part of Chapter 44, it is hard to imagine how an unfinished weapon parts kit requiring conversion could be helpful. At minimum, this understanding would seem to imply a crime during which the criminal could take some untold amount of time to convert his kit into a functional gun before using it. That does not fit any crime of violence with which I am familiar. Holding otherwise, the majority reasons that, as a thing created by humans, the term weapon may encompass not only weapons that are combat-ready, but also those that are disassembled, and that the term thus captures weapon parts kits in the same way and for the same reason. The majority again conjures up the artifact noun to support an interpretation that is incompatible with our traditional methods of statutory construction. Unlike a disassembled firearm, a weapon parts kit requires more than merely assembling the parts to become a functional gun. Special tools and an indeterminate amount of time are required to convert an unfinished weapon parts kit into a functional weapon. Thus, even assuming that the ordinary meaning of weapon does not resolve whether the term includes weapon parts kits, at minimum the term weapon cannot encompass weapon parts kits in the same way it covers disassembled firearms. The majority also insists that the term weapon should cover some unfinished instruments of combat like weapon parts kits because Section 921A, 3A, includes starter guns, which, like weapon parts kits, can be converted into functional weapons. But, because a starter gun does not fit within the ordinary meaning of weapon, Congress's decision to expand that term to cover that one specific object does not imply that Congress intended the word weapon to also cover other objects that are not already weapons. And, both a disassembled rifle and a starter gun are weapons for the reason a weapon parts kit is not. Disassembled rifles and starter guns typically have functional frames or receivers. The text, context, and structure of Section 921A, 3, leave little doubt that weapon parts kits are not firearms, and that the unfinished contents of these kits are neither frames nor receivers. But, even if it were reasonable to treat artifact nouns differently, the government would, at most, demonstrate statutory ambiguity. And, when a statute with criminal applications is ambiguous, the rule of lenity applies. This case is similar to United States v. Thompson/Center Arms Company. There, a majority of the court applied the rule of lenity to interpret a tax statute with criminal applications. That case presented the question whether a gun manufacturer makes short-barreled rifles, and is thus subject to the NFA's making tax, by selling a pistol and conversion kit from which one could make a short-barreled rifle. After considering several arguments, including analogies to products that require some home assembly, and comparisons to terms referring to any combination of parts, the plurality concluded that it was left with an ambiguous statute. And, because the provision carried the threat of criminal sanction, the plurality held that it was proper to apply the rule of lenity and resolve the ambiguity in Thompson/Center's favor. Justice Scalia concurred in the judgment. Whereas the plurality found ambiguity in the conversion kit's potential uses, he attributed the ambiguity to a much more fundamental question: whether the making of a regulated firearm includes the manufacture, without assembly, of component parts where the definition of the particular firearm does not so indicate. He found persuasive the contrast between the definition of regulated objects that expressly included any combination of parts, and those that did not, because neither the definition of rifle nor that of short-barreled rifle incorporated combinations of parts. These distinctions made clear that the NFA did not encompass Thompson/Center's pistol and conversion kit, or at least did not do so unambiguously. I would take Justice Scalia's approach here. Nothing in the GCA suggests that the terms frame and receiver also include the materials that one could use to create them, or that parts including neither a frame nor a receiver could constitute a weapon. There are, however, many reasons to conclude the opposite. Even the government appears to have found these competing interpretations persuasive just a few years ago. Now it says the opposite. The law hasn't changed, only an agency's interpretation of it. I would apply the rule of lenity here. Congress could have authorized ATF to regulate any part of a firearm or any object readily convertible into one. But it did not. I would adhere to the words Congress enacted. Employing its novel artifact-noun methodology, the majority charts a different course that invites unforeseeable consequences and offers no limiting principle. I respectfully dissent. Justice Alito, dissenting. The court decides this case on a ground that was not raised or decided below and that was not the focus of the briefing or argument in this court. Specifically, the court concludes, 1. That respondents mounted a facial challenge to a Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF, rule implementing provisions of the Gun Control Act of 1968, 2. That a party making such a challenge must meet the test that applies when a statute is challenged as facially unconstitutional, what I will call the Salerno test, and 3. That respondents cannot satisfy that demanding test. If I were satisfied that the Salerno test should control here, I would join the opinion of the court. The court points to a gun kit that is all but assembled, and a frame that is as close to completion as possible. As applied to those extreme situations, the court holds, and I agree, the rule does not deviate from the statute, but I am not certain that the Salerno test should govern. Respondents' petition for review in this case claimed, among other things, that the ATF rule goes beyond what the Gun Control Act permits, and that it should therefore be set aside under Section 7062 of the Administrative Procedure Act, 5 U.S.C. Section 7062c. In the Fifth Circuit and other courts of appeals, that provision has long been understood to permit a court to hold that a rule is invalid in toto. Thus, in both the District Court and the Court of Appeals, the parties appear to have proceeded on the assumption that the question presented was simply whether the ATF rule exceeded the agency's authority under the Gun Control Act. The government defended the rule as a correct interpretation of those statutory provisions and made no mention of the Salerno test. And for the most part, that was the position advanced in the government's briefs in this court. As the court points out, however, one paragraph of the government's brief did make the Salerno argument. But other than quoting language in INS v. National Center for Immigrants' Rights Incorporated, the brief made no effort to explain why that test should apply. And perhaps because of this cursory treatment, none of the respondents addressed the Salerno issue in their briefs or during oral argument. Noting this silence, the court regards the applicability of the Salerno test as undisputed, and it then proceeds to apply that test. On the record here, I would not hold that respondents agreed that the Salerno test should apply. The court relies on the use of the term facial in their complaints, but that characterization of their challenges did not constitute agreement with the proposition that a facial challenge to a regulation must satisfy the Salerno test. And in fact, respondents never conceded that point. They did not address the issue at all in their briefs, and at no point during the lengthy oral argument in this case were they asked about that question. Holding that they conceded the point is unwarranted and extremely unfair. And in any event, we should adjudicate a facial challenge under the right test regardless of the parties' arguments. That brings me to the question whether the Salerno test should apply. In Moody, I set out what I saw as the chief reasons for using that test when a statute is challenged as unconstitutional. One of the most important of these is respect for the lawmaking authority of the legislative body that enacted the law in question. A law passed by Congress or a state legislature should not be held to be entirely unenforceable just because it would be unconstitutional to apply it in just a few situations. That would represent unjustified judicial interference with the authority of the body entrusted under the federal Constitution or the Constitution of a state with the authority to make law. This threat to legislative authority is not present when a regulation is challenged. I recognize that two of our decisions support the use of the Salerno test in cases involving facial challenges to rules. But neither decision explained why the Salerno rule should be extended in that way, and in neither case did the court grapple with the question that has recently arisen regarding the scope of a court's authority under Section 706(2) of the APA. Applying the Salerno rule in a case in which a rule is challenged under that provision as exceeding the agency's statutory authority may have far-reaching consequences. As a commentator has observed, Salerno would seem to dictate that a plaintiff who challenges a rule cannot ever win unless he can show that there is no set of circumstances in which the regulation would be consistent with the statute. And because it would take an extraordinarily obtuse agency to write a regulation so completely wrong as that, applying Salerno in the statutory context would seem to dictate that plaintiffs would always lose. Thus, this extension of Salerno would represent a huge boon for the administrative state. It would also all but settle the debate about whether Section 706(2) of the APA authorizes a court to render a rule unenforceable across the board. Respondents asserted a typical claim seeking to have a rule set aside in its entirety under Section 706(2). And if that claim fails because there are at least some situations in which the application of the rule would be lawful, then it seems to follow that virtually all such claims will fail as well. The understanding of the set-aside power that has long been prevalent in the courts of appeals will be overturned, and parties who may be adversely affected by a rule will be reduced to filing as applied challenges. Perhaps that is what the law calls for, but we should not effect such a change without thorough briefing and argument. For these reasons, I must respectfully dissent. I would either direct the parties to brief the Salerno issue or vacate the judgment below and remand so that the issue can be addressed first by the Court of Appeals. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.